Punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 0088. All right. Court is calling 2024 CR 008999, State versus Noel Anthony Rodriguez. Mr. Rodriguez, if you'll come down, if I could have parties announced for the record for the state.
Robert Robach for Noel Rodriguez.
And are you Mr. Rodriguez? All right, you entered a no contest plea on October 16th, 2024 to the offense of choking. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 008862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objections, Your Honor.
Have both parties had a chance to review the TAP evaluation, state? Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of. He has committed multiple acts of family violence, and one in October of 2023 was a choking and strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check actually, Judge. He has been convicted of a lawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County, for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023. And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County, it has been revoked. The state does not believe that he would be a good candidate for probation, and we ask that you sentence him to no more than 10 years TBC.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of
objection
those.
to the court reviewing the certificates?
No objection.
So has spent his 168 days productively in custody and is ready to return. He has to support his 2 children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow follow your rules and not come back here.
All right, defense. I'm sorry, state.
Judge, to answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. On the assault, choking strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right. And then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right. Is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. All right, so what was this argument about?
I can't even remember that day.
All right, because according to the stipulations, it states that the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck, choking her. So you don't remember any of that?
No, Your Honor, I was putting my daughter to sleep that night and she had been in the restroom. I was having difficulty putting my daughter to sleep and I had asked her to help me. She ended up picking up our daughter and she started rocking her, putting her to sleep after that. I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right, well, in the report, they make it seem as though you choked her and then you cut your hair and then you left.
Uh, that day, um, it's hard to recall that day, but I know that when she had started choking me, and
Oh, so you're saying she started choking you first?
yes, ma'am.
Okay, you may continue.
After that is I started going back at her, and I regret it deeply. It's just
Okay. All right, any questions?
No, Your Honor.
State any questions?
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation, or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer, when this report was being prepared, he did not want to talk about the incident, right?
I told the probation officer that I couldn't recall it fully.
Okay, so you did say that you had difficulty remembering, but then you also said that you'd rather not talk.
I didn't want to talk about it without remembering it fully.
Okay, but you do remember that she started it?
Yes, sir.
Okay. How is that accepting responsibility if you're blaming it on her?
I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the 6th, right? Of 2024? For choking?
Yes, sir.
And then again on June the 9th of 2024, right?
Yes, sir. Or June 9th. That day I didn't really do anything. I had OD and my wife had called the saying that she needed ambulance.
No further questions, Judge.
All right, anything else from the
No, I
defense?
think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right, the court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact he has two children, and he has a household that needs him, we request the cap be the minimum of 2 years.
All right, state, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any drug or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible
Yeah.
to get the no contact order dropped?
No. And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, because 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history. And I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here. And that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
Yes. Your
All
Honor.
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your drug issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
On my release, I plan on going to CHCS, Center for Healthcare Services.
Okay,
So
that's
I'm ready to
great.
Get my primary care doctor back on vacation.
All right, awesome. Make sure that you stay on top of that, okay? Up to you.
Thank you, Judge.
Thank you. All right, which case is that on?
Give me just a second, Judge. I'm trying to find it for you. remember which one it was off the top of your head. Was he evading? Yeah, I think you're right, actually. Evading, it was an evading arrest charge, evading arrest in a motor vehicle case, Your Honor.
All right. Well, we have two evading arrests. Well, we have the evading arrest detention second or more,
I believe it was the one in the vehicle.
the vehicle.
Yes, ma'am.
All right, are you ready to proceed on this motion?
Yes, Judge.
Thank you. The whole website's down. Okay, I mean, it's still.
All right, court is calling 2024 CR 3794 State versus Joshua Anzadua. Could I have parties announced for the record for the state?
Megan Galloway for the state.
Adam LaHood for the defendant, Your Honor.
And are you Joshua Anzadua?
Yes, Your Honor.
All right, defense has filed a motion to have bond set in this, but of course, with e-discovery, it is somewhere in the ether, yes. Or in the time continuum, somewhere lost. Any objection to proceeding on the motion orally state?
Oh, Your Honor.
All right. So defense, you're requesting a bond?
We are, Judge. He was on bond, and then there was a subsequent arrest, a case which we tried to resolve via plea, but I think we're headed to trial on it. Due to the subsequent arrest, he was remanded without bond, which would make it impossible for him, obviously, to be released from custody. We're asking the court to either reinstate the bond or set some bond in some amount that gives him any chance. Obviously, while he's remanded without, he just simply has no opportunity at all to post a bond, Judge. And for that reason, we're asking the court to set a reasonable bond in this case.
All right. And what amount are you requesting?
Your Honor, due to, and it is without the bond, and just so we're clear, it's in the cause number ending in 3794. Previously, I believe his bond was 10,000. 10,000. We understand there's consequences for the arrest, Judge. We would be okay if the court set a bond at 20,000, which would essentially be double what the previous amount was.
State?
Judge, we request a $50,000 bond, given that original charge, the offense date was November 23rd of 2023. There were multiple other subsequent the subsequent arrest, but it's multiple offenses that stemmed out of that additional arrest, and for that, and because of the criminal history as well, that is the reason that we.
All right. What is the defendant's criminal history?
Sentenced on a possession of controlled substance, PD 1.124 grams.
And what date was that? Or the date of the offense?
Offense date was in 2019. He was awarded probation in that, but ultimately he was sentenced in 2020.
All right. And the cases that he has open in this court? What?
Judge, he does have one more case that he was sentenced on. It is a bird have intent to commit assault. That offense date was in 2020, January of 2020, and he was sentenced September of 2020. The offenses that he has pending in this court include the instant offense, the evading arrest.
Please make sure that's off. Yes, you may continue.
With the vehicle, 2 assault peace officers, 1 possession controlled substance, PG 1.124, an evading detention, second and more, theft. Well, then he has 2 misdemeanors pending, a theft 100, 750, and criminal mischief 100.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Joshua Anzaldua.
All right. Sir, have you ever been diagnosed with any mental health issues?
Manic schizophrenic.
All right, and have you ever received medication for that?
Currently on medication right now for,
All right. And then if you were released, do you have a place to live?
yes, ma'am.
And that place where you would be living, is that equipped with a landline phone?
Yes, ma'am.
All right. Do you have any children?
A 2-year-old, I believe, that I just barely found out about.
All right. Has there ever been any drug use in your past?
Yes, Your Honor.
And what would that be?
Methamphetamine,
And how often in your past were you using?
occasionally,
What does occasionally mean?
almost every day.
All right. Any questions from either side?
Nothing from the defense, Your Honor.
All right. Do you want to question him about the amount of bond he can make? Yeah. All right. Who has that phone? All right. Do you know how to turn it off?
I'll assist him, Judge.
All right. Thank you so much. They keep coming out with newfangled ways with the phones, and it's hard to know how to turn them off. Do you want to question him with regards to the amount of bond he can make?
Yes, Judge. So, Mr. Anzaldúa, are you working right now?
Not at the moment due to incarceration.
Okay. Before you were incarcerated, where were you working?
At Garcia Foundation,
And how much were you making? Either were you paid by the hour, by the day?
by the day,
How much are you making per day?
$80 a day.
$80 a day?
Yes, sir.
Are you able to go back and work there if you are released?
More than likely.
More than likely. Okay. What do you have any substantial savings right now?
Not at the moment.
What about family, mother, father, brother, sister, people that could assist you?
Yes, mother.
Your mother? If you've talked to her, do you know roughly what total bond amount you could possibly make? Okay.
I will be able to make something.
Okay. But you have talked to your mom about the possibility of getting out or her helping in post bond?
Yes, sir.
All right. And is your mom retired or working?
She's working.
Where does she work at?
She's a CNA.
CNA? Oh, like certified in nursing?
Yes, sir.
All right. We'll pass the witness, Judge.
All right. Any questions?
Just briefly, so when you were on bond previously, was it your mother who posted your $10,000 bond originally? Okay, who was that?
My girlfriend.
And you said that your mother works, correct?
Yes, ma'am.
And has she made any efforts to secure bonds in any of the other cases where bond was set?
No, ma'am.
And I guess if you're released, are you gonna be living with your mother?
Yes, ma'am.
And is that in a house or an apartment?
A house.
Does she own that house?
Yes.
And how long has she lived at that residence?
About 3 years.
Nothing further on it.
All right. This is what the court is going to do. The court is going to set your bond at $30,000. There's to be partial GPS. The court will waive fees. And the partial is for employment and mental health appointments. I'm going to do a referral to Center for Healthcare Services, outpatient treatment, outpatient drug treatment, waive fees.
Thank you, Your Honor.
All right, Ms. Ferguson, if you can make sure that he has a reset form, please. All right, thank you.
Thank you, Your Honor.
Just a second.
Who's here on Randy Wayne?
The hearing begins with Judge Stephanie Boyd reviewing Noel Rodriguez's plea, a no-contest plea to a choking assault with a sentencing cap of 10 years. The state immediately opposes probation, laying out a troubling pattern, multiple acts of family violence, a prior choking case where the victim withdrew, a deadly weapon conviction, and a probation revocation in Wilson County. Even more alarming, Rodriguez committed another assault 3 days after bonding out for this one. The defense counters with his 168 days served, anger management progress, 2 children who rely on him, and mental health needs. They argue he has learned his lesson and deserves structured probation, not prison. Judge Boyd asks detailed questions about prior victims and inconsistencies. When Rodriguez testifies, his version shifts again, suggesting the complainant attacked him first. Judge Boyd challenges him with documented injuries, bruising, redness, scratches, photographs, and physical evidence. The state confronts him about refusing to discuss the incident with probation, questioning whether he is truly accepting responsibility. Despite his remorse, the record is clear. Judge Boyd denies probation, finds him guilty, and issues an affirmative family violence finding. The state pushes for 10 years. The defense begs for 2. Judge Boyd settles at 6 years in prison, citing the repeated violence and ongoing safety concerns. She adds no contact orders, recommends therapeutic programs, and warns him that consequences always follow violence. Her closing is stern but compassionate, acknowledging his children while insisting that accountability and rehabilitation must come first.